Hello, welcome to my channel. I'm Leanne Newton, and today I'm doing this shorter video to briefly cover some of the filings that I didn't cover in my video yesterday. I'm also on X, where I write threads on these filings in real time. I'm not a US attorney. I'm qualified in UK law. Everything I say is my personal opinion as someone who understands and interprets the law. It is not intended to be legal advice. I would appreciate it if you could please like this video and subscribe to my channel. You can also press the notification bell to be alerted to future content. So what did we miss? Judge Lyman ruled on Lively's motion to compel financial disclosures from Wayfarer. Lively filed a mammoth 1,030-page motion to dismiss against Jed Wallace in Texas. And yes, I read all of it. Lively tries to make a bizarre claim that Brian Freedman was acting as Jed Wallace's lawyer in February. So we have Wayfarer and Jen Abel's opposition to Stephanie Jones's motion to dismiss due on Thursday. And I wanted to get ahead of that by discussing one of the protections she's trying to shield herself with. Let's begin by looking at the definition of the Speak Out Act. This is an act of Congress passed in 2022, in which Stephanie Jones is seeking to rely upon to protect her for effectively breaching her confidentiality agreement with Wayfarer when she shared the information from Jen Abel's phone. The Speak Out Act was passed due to recognition that there was a high percentage of people who experience workplace sexual harassment or sexual assault and do not report their experience. The Act is designed to remove non-disclosure agreements built into contracts in order to prevent victims from being silenced and to allow people with knowledge to discuss that knowledge without fear of legal ramifications. Stephanie Jones appears to be asserting an obligation to disclose the text under this Act, almost as a plan B in the event that the Vanzan subpoena turns out to be improper or illegal, something I believe is likely. However, I see a major flaw in Jones's attempt to successfully claim any protection under the Speak Out Act. So the Vanzan subpoena is described as requesting all documents and communications relating to Lively, her husband Brian Reynolds, their companies, and Baldoni, as is highlighted here on the right in blue. This is from the Daily Mail article. However, in the Deadline article on the left, the subpoena specifies wanting the information collected from a mobile phone, and it did a whole post on how specific that request was. For me, it was evidence that Lively knew exactly what to look for. The subpoena specifically requests information about Baldoni, which blows up Lively's assertion that she did not know the identity of any of the does. I can't see how she can argue both that she didn't know any identities whilst also arguing that she needed information specifically about Baldoni and specifically from his former publicist. But I'm now digressing a bit as I was talking about the Speak Out Act. I know it's hard to see, but here I have highlighted the nature of the causes. In yellow, it says, this action arises out of an ongoing campaign to damage plaintiff's business and plaintiff's reputation. In green, it says, upon information and belief, the DOE defendants have certain contractual and confidentiality obligations of good faith and loyalty to plaintiff regarding plaintiff's business and reputation by way of oral promises and/or written agreements. In pink, it says, despite these obligations, the DOE defendants have undertaken direct efforts to contravene these agreements and instead have participated and may continue to participate in efforts to harm plaintiff, including by failing to act in plaintiff's best interest, taking actions to their personal benefit at plaintiff's expense, failing to freely communicate with plaintiff regarding matters that impact plaintiff's business and reputation, and disclosing to third parties, and failing to keep strictly confidential plaintiff's confidential and/or private information. In orange, it says, this conduct constitutes breach of the agreements and obligations owed by the DOE defendants to plaintiff and has caused significant reputational and economic damages to plaintiff. My problem here is that there is nothing that mentions sexual harassment or retaliation, so there is nothing that ties the sharing of this information to any protection under the Speak Out Act. And I think Jones would struggle to claim for the protection applies to her notifying Sloan of the messages. Jones never claimed any obligation under the Speak Out Act in her original complaint, and the communications were not provided to Lively through any lawsuit that included actions for sexual harassment or retaliation. If there was genuinely a need to divulge the communications because of sexual harassment claims, then a proper lawsuit should have been filed with properly identified parties and a subpoena issued that adhered to correct processes and procedures. I've said this before and I will say it again. If you have a good case and believe in it, you don't need to skirt the process and deploy underhand tactics. For the sake of completeness, let's just check the 3 causes of action in the Vanzan lawsuit, just to make sure that there is nothing about sexual harassment in them. So here's the cause of action. First one, it's breach of contract. Well, that's not sexual harassment. Here's the second cause of action. That is breach of covenant of good faith and fair dealing. Also, not sexual harassment. Finally, the third cause of action, the faithless servant liability. Also, not sexual harassment. I've said before that the Vanzan lawsuit felt most closely mirrored to Stephanie Jones's lawsuit against Jen Abel, and nothing like Lively's claims against, well, anyone. So if the subpoena was obtained through a lawsuit that was in no way related to any claims of sexual harassment or retaliation, how can Stephanie Jones cite the Speak Out Act to justify breaching client confidentiality? My own belief is she can't. So now we have the judge's order on the motion to compel, the financial disclosure one. To clear up some confusion, Lively's motion to compel had 2 parts to it. One was requesting that the judge compel non-parties to comply with Lively's subpoenas. That's people who are not parties in the lawsuit, such as people who work for Wayfarer. That's the first part of the motion. The second part was a request to compel financial disclosure, which is reasonable, given Wayfarer has very publicly stated they are seeking substantial damages from Lively. Lively will also be required to turn over this information. Reynolds and Sloan likely won't, as they're not pursuing claims, and neither is the New York Times. So the judge granted the motion to compel as far as net worth and assets go, but denied the request for disclosure of tax returns. And this is a fair ruling. So next we had Lively's motion to dismiss from Texas. Lively filed a request to exceed the 20-page limit on filings in her Texas lawsuit against Jed Wallace. The request was unopposed by Wallace, and the judge granted it. Lively exceeded that filing cap by 1,010 pages, and I had to read every single one. Now, most of it was the same allegations from her previous motion to dismiss, and the same arguments over jurisdiction, so I'm not going to cover that. Some brief points of note were Lively claiming that she is being muzzled, despite the fact that she has not stopped talking since she made her allegations. She also claims that Jed Wallace is being funded by Wayfarer without any context or evidence to support this. Lively also suggests that misleading stories were put out blaming her for production members' job losses. My personal view on that statement is, if that allegation is untrue, you'd think she would use the word falsely rather than misleadingly. One categorically denies something. The other suggests that it happened, but not quite the way it's been described. Lively suggests that by commencing his lawsuit in Texas and not New York, Wallace is further penalizing her by forcing her to fight claims arising from the same set of facts 2,000 miles apart. She asserts that she intends to claim her attorney's fees, costs, and damages under California Civil Code 47.1b. This is the treble damages for retaliation under the sexual harassment privilege. Lively then sums up that Wallace, who had no involvement in any sexual harassment claims and was not even retained by Wayfarer until more than a year after they had allegedly occurred, is equally responsible and had an unsubstantiated desire to retaliate against her. I've added my own little flourishes to that statement. It's just how I feel. For me, I am troubled by these statements by Lively about Wallace, saying that he is punishing her, that he is retaliating against her. Lively has not made any attempt to explain why Jed Wallace would have any motive to want to punish her, or what he's retaliating against. She hasn't even suggested that Wallace even knew Wayfarer or Baldoni prior to this lawsuit, so I don't see his incentive for any involvement here. I did come across something interesting though. This is a certificate of conversion for Street Relations. Street Relations is obviously Jed Wallace's company. Lively points out that it has Brian Freedman's law firm as the service address, and these are the parts I have highlighted in yellow. I do appreciate it. It's really difficult to see. So at this part of her motion to dismiss, Lively asserts that this is evidence that Freedman's law firm represented Wallace originally, and tries to tie this to comments Brian Freedman made at the hearing on the 3rd of February regarding the lawsuits all being consolidated in New York. Lively also asserts that Freedman's firm should have accepted service for her Rule 202 deposition petition because of the ties Freedman has to Street Relations. This is Lively's notice of nonsuit for the Rule 202 petition in Texas. A Rule 202 petition is an order for a pre-litigation deposition. The petition was for the deposition of Jed Wallace as an individual. Lively is trying to assert that Freedman, acting as an agent for Street Relations, The company means that Freedman is de facto an agent for Jed Wallace, the individual. It doesn't work like that. Anyway, that is all for me from now. Thank you for joining me, and I will be back soon.